American shale companies are playing a game they're legally barred from winning. When a private company deliberately floods a market to bankrupt its competitors, that's a federal crime, a Sherman Act violation. When a foreign government does the exact same thing, it's untouchable. The tool is called sovereign immunity, and it's the reason OPEC has never once been successfully prosecuted for the thing every antitrust lawyer agrees it's doing: coordinating supply and price like a cartel. This isn't a gap in the law, it's a shield built directly into it. That's what this documentary is going to do. Here's the actual mechanism. The Foreign Sovereign Immunities Act shields foreign governments from U.S. courts. Layer on top of that a legal doctrine from 1897, Underhill versus Hernandez, which says American judges won't second-guess what a foreign government does within its own borders, and you get a cartel that's completely legal, as long as its members are countries and not companies. In 2014, Saudi Arabia led OPEC into flooding the market specifically to break American shale producers. It worked. Dozens of U.S. shale companies went bankrupt over the next 2 years. If a private company had done that on purpose, the Justice Department would have had a case. Because it was sovereign states, there was no case to bring. The mechanism itself is simple. A private U.S. driller has to answer to shareholders, lenders, and quarterly earnings. A state-owned producer answers to a government that can absorb losses for years, funded by a national treasury instead of a balance sheet. That's not a competitive advantage a court can fix. It's a structural one, built into who's allowed to lose money without consequence. Congress has tried to close this exact gap for over 2 decades. The bill is called NOPEC. It would strip that immunity specifically for oil cartel behavior. It has been introduced, debated, and advanced through committee, including a 17-4 vote in 2022, and it has never once become law. In 2019, Saudi Arabia gave Washington a preview of what enforcement might cost. If NOPEC ever passed, the kingdom threatened to start selling oil outside the dollar entirely. Today's shale industry didn't get the law changed. It got bigger instead. The top 5 U.S. producers now control roughly 70% of total output, built through hundreds of billions in mergers specifically so they're large enough to survive the next price war without needing a court to protect them. The shield is held. Now the battle shifts from the courtroom to the market. This is the same pattern playing out at the level of entire nations now. Global trade restrictions tripled to over $2.6 trillion by mid-2025, as countries move toward openly protectionist policy to secure their own strategic industries. Washington's own answer has a name: energy dominance. Maximize domestic production, cut regulation, reduce reliance on anyone else's oil. It's not a courtroom solution. It's an attempt to make the loophole irrelevant by never needing it in the first place. So which is it? A legal gap that eventually gets closed once enough political will exist? Or proof that until international law itself changes, the American energy market stays a legal battlefield with only one side allowed to fight? A. NOPEC eventually passes and closes this. B. The loophole outlives another decade of attempts to close it. Comment A or B. Full documentary every Thursday. Subscribe and like, and hit the bell so you never miss one.